Hi, welcome back to Intellectual Property, Trademark Edition. In this episode, we're going to be talking about the functionality doctrine in trademark law. And the critical thing to understand here, or to remember here, is that functionality means different things when it comes to different kinds of intellectual property. And in particular, I'd encourage you to kind of keep in mind what it means to talk about functionality in relation to, for example, design patents and copyrights when you think about or understand what it means to talk about functionality in relation to trademarks, because it doesn't work the same way, right? What it means for something to be functional with respect to a mark is not the same thing necessarily, anyway, that it means for something to be functional when it comes to a design patent or a work of authorship. So, broadly speaking, the functionality doctrine provides that trademark law can't protect the functional elements of a product, right? So we've talked about trade dress protection, right? So it's very clear that trademark law can protect the appearance of a product insofar as the appearance of the product conveys information about source to consumers. In other words, if it's distinctive because it's communicating information about the source of the product to consumers, then it can be the subject of trademark protection. But functionality is a carve out there. Essentially, what functionality says is that even if a feature of a product communicates information about source to consumers, it can't be protected by trademark law if it's functional, right? If it contributes to the functionality of the product in question. So that's not a decision, or it's not an observation about the meaning that's being communicated, but rather an observation about the nature of the feature of the product in question. In other words, when we talk about functionality, we're implicitly making a policy choice, right? We're making a decision about the kinds of things that can and should be the subject of trademark protection, as opposed to the kinds of things that shouldn't be. And I think that's really nicely illustrated by the case that you read for today's class. So in Trafix Devices v. MDI, what happened here? Well, both Trafix Devices and MDI are companies that make road signs, right? So they're creating they're creating signs to be used on the side of the road to indicate various kinds of traffic situations. And Marketing Displays Incorporated, MDI, benefited from a set of utility patents, right? So these are the Sarkeesian utility patents in relation to a, uh, a, a, a a design that enabled the road signs in question to move back and forth in the wind based on a two-spring design that enabled them to have smaller bases and blow over less frequently, right? So this is a patented design that makes the road signs work more effectively. And, they have a patent on this design for 20 years. MDI makes a mint selling road signs with this two-spring design that makes their road signs preferable to other road signs and encourages various municipalities and construction companies, etc., to purchase MDI signs because they blow over less frequently than the competition. Okay, eventually the MDI patent expires, and other companies, including Trafix, one of their competitors, starts making similar signs using the same two-spring swinging design that prevents the signs from falling over. And MDI brings a trademark infringement action against Trafix, right? Essentially, they say, look, consumers, or the relevant consumers, have come to associate this particular design with our company, right? When people see this two-spring design, they think MDI. They think it's an MDI product. We've had the exclusive right to produce this kind of traffic sign for 20 years. And as a consequence, consumers have come to associate this particular element of product design with us, right? They see this design, they see this two-spring design, and that two-spring design says MDI. Okay, the Supreme Court ultimately says, no, that's not how it works, right? Yes, MDI, we understand that, you have an argument that there's more than one way to accomplish this goal, right? So your argument is, look, this isn't the only way of making a sign that doesn't fall over. There are other alternatives. You could use more springs. You could use springs in a different configuration. You could put springs in different places. But the point is, the reason that this particular design became associated with your company is precisely because you had the exclusive right to use it for 20 years. The reason that it came to communicate information about source is because of the utility patent, right? And we can look to the utility patent and use that utility patent as a prima facie basis for believing or understanding or inferring that the feature in question is functional, right? Because it's a utility patent, we can infer that utility patents are functional because that's what utility patents are for. And so even if there are alternative approaches, it doesn't matter, especially because when you had the utility patent, you claimed across all the different approaches to the same design. You can't take it back now. You have to accept that when your utility patent expired, so too did your exclusive right to use that particular product design. Other companies, you need to be able to use the same design in order to be able to effectively compete with you. And the fact that there are conceivable alternatives or other ways of accomplishing the same functionality isn't enough, because it's not clear that those other ways of accomplishing the same functionality are as desirable as this one. In other words, what you're trying to do, MDI, is monopolize the best way of creating this product, and trademark law is not intended to let you accomplish that goal. The purpose of trademark law is to ensure that consumers aren't confused by marks that communicate information about source. There are other ways of communicating information about source than this particular product feature. Is it true that this particular product feature does in fact communicate information about source? In other words, does it have secondary meaning right now? Sure, because you had the exclusive right to use it for 20 years, right? But there are other ways that you could accomplish the same goal. And the reason it communicates information about source isn't really a trademark reason. It's a patent reason. And you can't bootstrap trademark law onto patent law. In other words, all of your competitors who've been shut out of the market from this particular product for 20 years while you were coasting on this patent, they now have the opportunity, they need to have the opportunity to compete on this particular product feature. And you can't use trademark law to accomplish what you used to be doing with patent law. You have to find a new way, a different way, a trademark way to communicate information about the source of your product.